Due Process, winner of 18 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2010 Mid-Atlantic Emmy for Best Discussion Series.
I'm asking for your support for an institution which is going to decide things often that are unpopular, and sometimes their decisions are wrong. Oh my goodness, why should I support that? And that is the question that Alexander Hamilton asked.
The institution, the U.S. Supreme Court. The Speaker, Supreme Court Justice Stephen Breyer, up next on Due Process.
Major funding for Due Process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.
Welcome to this special edition of Due Process, coming to you not from our studio, but from the historic Essex County Courthouse in Newark. I'm Raymond Brown.
And I'm Sandra King, and it is in courtrooms like this one throughout the country that countless cases, criminal and civil, are decided each year. Most will end with that verdict or plea, settlement or trial. But a tiny percentage, just 80 in this last high court term, will step by step, appeal by appeal, make their way to a hearing by the U.S. Supreme Court, where the test is a not-so-simple matter of constitutionality.
So whether you're a lawyer like me or a legal journalist like Sandy, a chance for an extended conversation with one of only 9 Supreme Court justices before an audience at Rutgers Law School without ground rules or limitations on what we could ask.
And make that justice the erudite former Harvard prof. Stephen Breyer, who's written a provocative book on democracy and the court. And you've got an important event. And
some must-see viewing here on Due Process. Sandy starts it off on this week's Breyer special, the first of 2, and it's right to the point of Justice Breyer's contention that our democracy does work.
Justice Breyer, welcome to Rutgers Law School. Welcome to NJN. Thank you so much for agreeing to do this. I'm going to start with the title of your book, Making Our Democracy Work. When, without question, more Americans can name the 3 judges on American Idol than can name 1 judge on the Supreme Court, at a time when fewer than 60% of Americans choose to vote. What kind of shape is our democracy in?
That's a good question, and that's why I wrote the book. I think it's in pretty good shape. I'm always optimistic, and I really wrote this in order to tell people at just the kind of time you're talking about. People don't trust American institutions. A lot of them don't.
Yourself and Justice Scalia are probably the only justices who, in the written word, outside of the confines of the legal establishment, come out and engage in conversation. And obviously that's a choice each justice makes. Mm-hmm. And while I wasn't unhappy to see Judge Bork not get the nomination, I thought that perhaps the consequence of the process he went through meant that people who are engaged in the intellectual sphere, who write, who speak publicly, are less likely to get on the court. Is that a fair assumption, and does it affect the quality of what we can expect long-term from the court?
Who's nominated to the court? Who's confirmed for the court? Is something I'm only a little bit expert on. I know my own nomination. I was glad I was confirmed. Now, why I say that is because it's important to make a distinction between the person who does the nominating or the confirming and the person who is the person nominated or the person confirmed. Because for, I think, better, the process of appointing a judge does involve politics. But once that judge is appointed and puts on that robe, the political process is out the window. Now, you're asking me what should happen during that political process, and that's a little bit like asking the recipe for chicken a la king from the point of view of the chicken.
I've been a practicing lawyer most of my life, so that I would, to the justice, probably show some deference, but to the intellectual who wrote a book, feel free to challenge and say you've stretched a point
That's
here and there.
fair.
So the question is, does the fact that over time we may wind up with a court of people who have not over time done that because they've either been judges for a long time or people who've chosen to keep their ideas to themselves, might that affect the quality of the court?
Well, I would hope that wouldn't happen. Okay. I agree with you about that. I'm reluctant and avoided your question in part.
Very skillfully.
Because I wanted to emphasize that people who are not too happy with the way that the confirmation or even the appointment process, for whatever reasons are going, have a remedy, but it's not through the judges. Because the senators ask questions. And the one thing I learned is that they ask questions they believe their constituents want asked. I don't have to answer, but they have the right and the freedom to ask.
In your nomination process, you came out of the Senate Judiciary Committee unanimously. Of course, you had also served the Senate Judiciary Committee as senior counsel. There was speculation that perhaps they had a special place in their heart for you. But one of the things that you were quoted at the time as saying that you would judge with both your mind and your heart. And one of the things that Raymond and I were wondering is, what decision would we look at to see where your heart came in?
Well, ask the same question, most of them. I mean, judging is not a question of mathematics, and I'm sorry to say that because the husband of the former Chief Justice of New Jersey is a mathematician. It's not computer programming. It does involve people. And so every case is a case about how the law will be applied to a set of human beings. And in answering that case, where those questions are difficult, and if they weren't difficult, why are they in our court? We only take cases where lower courts, I won't say only, but almost always, the lower courts have come to different conclusions on the same question of federal statutory or constitutional law.
Can you think of a case where your heart and mind perhaps were in some amount of conflict and your heart won out?
Your heart and mind, that isn't the role of a lawyer. And I'm looking at the students directly. Because the job of a lawyer, and the job of a law student who will be a lawyer, and the job of a judge who is part of the profession, as you are, we understand perfectly well that there is a human being, and it does call for a heart. But you know, every single person, whether they're a lawyer or not, has a heart. And lawyers have something special. They have a trained ability which they can put in the cause of trying to help a client or trying to produce a society where law works better. They have a mind that they can put that heart in service to, or the mind, I can't now remember. It's easy for me to get mixed up. That, to me, is why it's a great profession to go into.
Let me enable you to reunite your heart and your brain.
Good. Didn't drive the boat
and focus on what I would regard as the core purpose of the book, which is to talk to not just lawyers but others about the legitimacy of the court.
That's right.
If we were to stop 100 non-lawyers, non-law students in the streets of, let's say, San Francisco, how many of them would respond affirmatively to the notion that one of the purposes of the Supreme Court is to put restrictions on the will of the majority? I mean, most of us are raised with the notion that the will of the majority.
They won't like that. They say, why in this country, which is a democracy, why should these people, 9 unelected people, have the power to tell us what to do, or what, put it more specifically, why do they have the power to set aside a law that was enacted by our elected representatives in Congress or in the state legislature? That is immediately people's instinct when you tell them the question you just said.
Now, I don't know if an associate justice gets to eat at McDonald's or Burger King. Probably not with the, but if you're sitting in a place.
Yes, you do, oddly enough.
Okay, all right. So in Burger King.
And if you think that that's sort of a letdown, you haven't tried the food in the Supreme Court café.
Okay. Right. So you've escaped from the Supreme Court cafeteria to Burger King, and a person asks you just that question. Say, I can't wrap my mind around the notion. I like you personally, but that there should be unelected people who place restrictions on what I learned in grade school was the prime moving force in this body politic, which is the will of the majority. How do you explain it in a way that's comprehensible?
Oh, I like that question. Can I first tell you why I like the question?
Sure.
Because I think that's the challenge. I think that's the challenge. That's exactly why I wrote this. It's not going to change the world, but maybe it'll change a few people. And what I want to do is say, what can we say to a man or to a woman who's busy? That's the first thing about people. You know, they have other things to do. They have families. They have jobs. They may have somebody at home looking after the children. They've got to get some food from the supermarket. And life for a lot of people isn't so easy, so they don't have the time. But the problem is, I think, that unless the average person understands why you might have this kind of institution, why you should have it, why, they won't support it. And if they don't support it, it won't exist. Because public support, not for any individual decision, but public support for the institution is necessary in a democracy. So there is the question. We're only to the question. Why? Ma'am, sir, why should you, in your busy day, stop to listen for 5 minutes to an explanation that's going to try to get you to support an institution that often decides things that are unpopular, very unpopular? You'll hate them. And in addition, I'll tell you a secret. Sometimes the judges are wrong because they're human beings. They aren't some kind of angel or genius. And so I'm asking for your support for an institution which is going to decide things often that are unpopular, and sometimes their decisions are wrong. Oh my goodness, why should I support that? And that is the question that Alexander Hamilton asked. If you read Federalist 78, you will discover right in that document that question. And there's a whole 200 years of history since then that helps develop that answer.
If we go back just to the year 2000,
Yes.
a decision that was at the very least controversial, one that did meet with not just disapproval and disappointment, but real skepticism on the part of much of our populace, Bush v. Gore. In the book, an example of the democracy managing to not be toppled by an unpopular, among some people, decision. You said it was not just very wrong, but a self-inflicted wound.
I was in dissent, that's true.
Exactly. But you also come out on the side of, we survived it, nobody took to the streets, we didn't have a revolution, and therefore the democracy was that much stronger. If, in fact, a sizable percentage of this population believes that that election was stolen with the help of the Supreme Court, does that put you in a far more difficult position in doing what you have to do?
No, that's all part of the answer to Ray's question, because we've got the question all right, and you've elaborated on it. But what in heaven's name did Hamilton say? Well, he said, I'll tell you what, if nobody has that power, here's what we'll do with the document. We'll hang it up in the museum. Put it in the National Gallery.
Justice
We're
Breyer,
doing, but, yeah.
could I just bring you back to Bush v. Gore?
Why did I like it? I liked what happened in this respect. And I heard Senator Harry Reid say this, and I couldn't have agreed with him more. And that is, after it was decided, even though it was unpopular, Gore had more votes, and Gore people, by and large, didn't like it.
And you didn't like it.
I didn't like it. Not only did I like it, I thought it was wrong. People did not start shooting each other. They didn't have riots in the streets. They didn't get out there with physical demonstrations and start throwing stones. When I talk to an audience, particularly, like this one, I perfectly well know, and maybe you're thinking this, too bad they didn't. So I say, before you decide that that's right, turn on the television set and look at what happens in countries that decide to decide their major problems in the streets with guns instead of under law in a courtroom. And that's why I've said that Bush v. Gore has a silver lining.
We all watch what happens around the world in other countries. But in truth, the other cases that you use, like Dred Scott, like the Brown case, like the Cherokee Nation cases, are cases where people were touched in their viscera. It's about race, it's about jobs, it's about land. So I'm saying that Bush v. Gore didn't touch the kind of nerve that would drive a truck through the Constitution or confidence in the court. It probably took a chunk out, as opposed to saying that it really proves that the institution's all right. I just think it wasn't enough of an outrage to people that they would do anything more.
I was fairly cautious. But the question is, why did Hamilton give the power to the court? In a sense, because he couldn't think of a better place to put it. Not the president, not Congress, but we have these judges over here, pretty gray. Nobody's ever heard of them. They're sort of bureaucrats. They have, they're like judges. Yeah, that's true. They'll be able to deal with this document probably like judges. They don't have the power of the purse. They don't have the power of the sword. So they're not too dangerous.
Justice Breyer, so far, Raymond and I have been the only ones who've had the opportunity to ask you questions, and I would like to ask former Chief Justice Deborah Ports to ask the first question.
Justice Breyer, Justice Brandeis spoke of the opportunity of the states in this federal system of ours to explore in the law in ways that the United States Supreme Court might not, because the United States Supreme Court sets a floor for the entire country. When you speak about, when you write about the principles for decision-making and the kind of pragmatism in your approach to decision-making, do you think that applies to state courts as well, or do they have greater leeway? Or, in fact, in states where judges are elected, do they have less leeway?
Well, I guess I would think generally is the interesting thing about the states is the much greater depth of experience a judge in a state court has. I mean, most law in the United States is state law. Family law is state law. Criminal law is 90-some-odd% state. Law of torts is almost all state. Business law is almost all state. And you can go in area after area, education, even the environment, one after the other. And therefore, let people try to work out these things as best they can in the states. I do think they have more leeway. Of course, that itself is a matter of state constitutional law.
Justice Breyer, if you were sitting in New Jersey rather than sitting on the U.S. Supreme Court,
which
you
wouldn't
would
be
have
so
been,
bad. That would be
well, you wouldn't be there
nice.
any longer,
Yeah.
because having
I'd have
passed,
to retire. All right.
having passed age 70, you'd have been forced,
Yes.
as Chief Justice Ports,
Yes.
to retire. I wonder where you weigh in on this question of federal judges and justices serving for life, should they choose, and state judges and justices, as in New Jersey, so often being forced to retire in New Jersey at age 70.
Well, of course, the retirement age is up to the state, and I can't really express a view except to say that I know many, many fine judges who unfortunately had to leave the bench. That's not just true in New Jersey. It's also true in Massachusetts. It's also true in California, a lot of places. What I really think is I think that it needn't be life. I do think it should be a very long term. And the reason it should be a very long term is a simple one. I don't think it's a good idea to have a judge on the Supreme Court, or probably in the federal system, who's thinking about what next job he or she is going to have. There's plenty to worry about in your present job.
Questions? Professor Alexander?
In the Citizens United decision last year, you joined the dissent where Justice Stevens was very scathing in criticizing the majority's opening up almost unlimited spending for corporations and unions. Can you explain to us how this, in your view, has an effect on our democracy?
It's a very good question. And the trouble with a good question is sometimes you get a very bad answer. So my very bad answer is going to be, I'm still rather hesitant to go beyond what was said in the dissent. And the dissent said enough to suggest that it was not happy with the result that was being reached in that case and thought it was not a correct result.
Is there a question on this side of the room?
You don't get an answer
Yes.
to the question.
My name is Sporga. I'm a current law student here. I have a question. You talked about popular versus unpopular decisions, but there's a new element that's here now that wasn't there before. You have a third of the bench being women. What impact do you think this will have on the future of court decisions going forward?
There's no way to say, really. I think it's, from my point of view, I like having a few more women on the bench. I think that's a good idea. And I think people do approach it with different experiences, and I think that it does somehow make a difference. And you're going to say, what difference? And then I'm going to say, I'm not sure. and there we are. So we're going to have to stop with my general approval of this idea and my general reluctance to try to analyze it too finely.
You have a question, second row.
Justice Breyer, earlier you mentioned the three branches of government, and I'm wondering if I could get your opinion on when members of the executive branch criticize members of the judicial branch. We had President Obama criticizing the court's decision in Citizens United.
Last week, the Supreme Court reversed a century of law that I believe will open the floodgates for special interests.
And in a more extreme example, here in New Jersey recently, we had the governor criticizing particular justices questioning at oral argument.
Criticism is the American way of life, and judges have to get used to it, and they do. People are free to say what they want. They may criticize or not as they wish, and that's about it. Now, how's that for an answer that tells you nothing whatsoever?
Justice Breyer, let me see if I can get
Yes.
you. This is in the penumbra of what you might not answer, but I think maybe we can get you to do it.
Right.
I think that your response to a question you gave in September was kind of treated unfairly and never got articulated clearly. That is, when you were asked by Mr. Stephanopoulos about the burning of the Koran and Reverend Jones, you gave an answer which was obviously thinking out loud. You only a couple of sentences, a lot of hue and cry. I think you tried to clarify it, and I can't figure out what you intended to say because I don't think you were asked in a way that gave you a chance.
No, what happened, because I was interviewed for television, not for a program that's specialized like yours, but for really general news programs.
And you gave him some headline.
Oh, well, here I learned a lot from that. I mean, I learned, for example, about how tough it is to be in political life. One group just prints the first thing, and it says, he said you cannot, under the First Amendment, shout fire in a crowded theater, and he thinks this applies, and we always knew he was a Nazi, and now this proves it. All right? No respect for the First Amendment. That's what they said. Now, the other group just prints the second part. It says he thinks it's fine to burn the American flag. Oh my God! And he's on the Supreme Court. Oh dear! All right, you see that. So I suddenly realized why so often a person who's in political life and all the time appears to be saying nothing, because if you say something, you're bound to get yourself into trouble. All right, that was my experience with that question.
And perhaps why so many of your fellows on the court don't come out and do this kind of thing.
Yeah, sometimes people will criticize you, and sometimes the criticisms will be right, and sometimes they won't. There
Cornell
we are.
Brooks, New Jersey Institute for Social Justice.
Yeah.
Justice Breyer, my question is as follows. You very powerfully invoked the Brown decision as speaking to the moral standing of the court. A half century later, a half century from now, which of your decisions in which you've been in the majority would be the Brown of that time?
I don't think any will be the Brown one way or the other. I mean, Brown was a very special case, and I think people recognized that at the time, and I think they've recognized it ever since. I mean, remember, the problem of slavery was a problem that divided America from its founding, and we thought it had been solved by a civil war, and then there were 70 to 80 years of lawful segregation. And people my age can remember that. And all you had to do was open your eyes and look. And it was a way of making certain that this country did, in fact, become a country where people were treated equally and belonged to the country just as much, no difference. And my goodness, I mean, think of this country. Think of what that took. And there is nothing like that, in my opinion, but we never know for sure, because history tells us things that we thought were not that wonderful or whatever it was at the time, and has an odd way of making us look back at something. And we then think, in light of the future events, that it was this key moment. All right, but I can pretty much guarantee, I think there's nothing like Brown.
And we'll hear more on Brown and the way it changed America, along with the range of legal concepts and cases at the heart of our democracy, when we pick up our conversation with Justice Breyer in part 2 of this due process special, taped on location at Rutgers Law School.
From Dred Scott and Korematsu to the Civil Rights era, from judicial philosophy to judicial temperament, Justice Breyer continues his candid observations on the court he served for 17 years. So there's more to come with Justice Breyer on the next due process. Till then, for Sandy and all of us here, I'm Raymond Brown. As always, thanks for watching.
Every American in 1957 knew who that 101st Airborne was. These were the heroes of World War II who had parachuted into Normandy, and they'd gotten hung up on the steeples, some of them, and shot down, and they were heroes of the Battle of the Bulge. And Eisenhower knew what he was doing. He selected them purposely, and 1,000 of them got on the airplane, and they flew into Little Rock, and they got off, and the next day, they brought those 9 children into that high school. And pictures were again taken of the pictures of those children, black children, going into that white school proudly, with dignity, surrounded by the troops. But that showed something was happening in the United States of America. And for me, that picture, that day, is a great day. It's a great day for the rule of law. It was a great day for the cause of equality. It was a great day for this country. September 1957, these 9 children will go into that school. What happened?
Major funding for due process provided by the New Jersey State Bar Foundation, committed to educating the public about the law, and by the Fund for New Jersey, supporting informed citizens for an effective democracy.